Someone asked me to look at this. It's not actually very interesting, despite Maximilian Ayer's attempt at propaganda. This happened on Tuesday, March 20th, 2018, Washington Township. It happened at the Department of Family Services in their parking lot. Somebody was living in his car. He was in the parking lot at least overnight, probably longer. The police showed up. We don't know exactly why they showed up. I'm going to assume they were called because the police typically come in numbers when they're called, but we don't know. This is what Daniel claims. We don't have any evidence to the contrary, but we also don't have any reason to believe him. When the officer arrived, Daniel was awake and talking on the phone. We don't know that, but anytime somebody has to go out of the way to say they were awake, then were they awake? How many times in your life have you had to say, oh, when the officer arrived, I was awake? And imagine a circumstance where that would be relevant to anything. Now, I'm not saying it's a crime to sleep in your car in New Jersey, but I am saying that he is desperately trying to make it sound like he wasn't sleeping. And that, to me, raises my indicator. But again, we don't have any testimony from officers. We don't have any body cam footage from officers, dash cam footage from officers, calls to the police, anything like that. We just have the testimony of Daniel, who is obviously vested in the potential outcome of this. So take that in mind, everything with a grain of salt. Then he says, without saying anything, the cop tried to open his door and then demanded he opened his door. That's when this recording begins. If someone is trespassing, defiantly trespassing, then the officer may arrest him for defiant trespassing. And yeah, I can imagine that this may have happened. I don't believe it happened exactly as Mr. Marsden is saying, because again, Mr. Marsden is going, or Madsen is going to attempt to dress this up to appear in the best light for Mr. Madsen. That said, there is a bucket of dirt in his car. You can imagine as well as I could what a bucket of dirt would be used for in a car if you're camping out in your car, at least overnight. Nature calls, buckets of dirt answer. That depositing your bodily functions, having bodily functions in and depositing them around a parking lot for the Department of Family Services may create a public nuisance. The officers ask him if he's there on business with the Department of Family Services. He says, oh, they know who he is. Yeah, he's very, very keen on proving who he is, but that is not what they are asking him for. They're asking him to open the window, to hand him the card so they can get access into the vehicle, and or exit the vehicle so they can get access to him. Either way, they're looking for access to him. You know it, I know it, he knows it. That's why he doesn't open his magical window of shielding from the police. He says, what determines if I have reason to be there? Well, if you're there to make use of the business for the purpose of the business, you are there for legitimate purposes. Is that a law? Yes. Yes, it is. Defiant trespasser. This is the New Jersey Revised Statutes. Defiant trespasser. A person commits a petty disorderly person's offense if knowing that he is not licensed or privileged. If you are there to conduct business, you are licensed and privileged to be there. If you are not, you're not. He enters or remains in any place as to which notices of trespass against trespass is given by actual communication. Was there? Well, the cops have given him notice, and maybe the persons there did. Maybe, we don't know, but it is potential. So until we have further evidence, bear in mind that it is possible he had received notice prior to the officers showing up, but the officers did give him notice, or posting in manner prescribed or by law or reasonably likely to come to the attention of intruders. So defiant trespasser, you may notice, is a petty disorderly person's offense. Bear that in mind. And then maintaining a nuisance. This would be public nuisance by conduct either unlawful in itself or unreasonable under all the circumstances. He knowingly or recklessly creates or maintains a condition which endangers the safety or health of a considerable number of persons. I believe this is what Snooki was charged with back in 2010. Her lawyer didn't fight this one. Basically, he got her to plead down to a local ordinance about being a nuisance on a beach. And they dismissed the disorderly conduct and the public nuisance charges against her. If I remember correct, you can look it up for yourself. I don't want to Google anything about Snooki. Thank you very much. But if I remember correctly, that's what it was. So we've established that much so far. And then somewhere around here, he says he was charged with, and we don't know that this is what he was charged with. This is what he was saying he was charged with. That evidence from the state or anybody else, we're going to just assume that this is probably what he was charged with. Disorderly conduct, that would be the 2C-18-3, obstructing, delaying a police officer, not opening your door, I guess could be. That's probably a tack-on charge, whatever. Hindering apprehension, again, not opening your door when they're trying to arrest you. Sure, that makes sense. Public nuisance, shitting in a bucket, pissing in a parking lot. Probably, maybe, we don't know. It all makes sense. Whether or not he did it, I don't know. You don't know. Only Daniel Madsen knows, and maybe the police officers know, but we don't have their side of it. So there's an interview with the man. I don't really care. He's going to obviously say that he was a good boy who didn't do nothing. So he says, what do you think? This wasn't a traffic stop. So did he have to get out of the car? Yes, he did. They were arresting him. He had to get out of the car. Even if they just had probable cause or reasonable suspicion, even if they just had reasonable suspicion that he was or did or is about to commit a crime, then they could get him out of the vehicle for officer safety reasons. That is what Pennsylvania v. Mims said. Even if you weren't driving and committed no offense, well, they have to have probable cause or reasonable suspicion you committed an offense. You didn't actually have to commit an offense. And even if you weren't driving, yes, see California v. Carney, a motorhome. It was parked in a parking lot. The Fourth Amendment, the version of the Fourth Amendment that applied was the one that applies to vehicles. So the automobile exception applied. Therefore, fun stuff. Did you know that public nuisance is a property code violation? It is also a property violation. And even in this one, there are portions of it that deal with property. But part A is by conduct. So it's conduct or property as far as the actual state statute is concerned. If he doesn't own real estate property, just a car, how can he be charged for a property code violation? He wasn't. Thank you for playing. That's like being charged for not having your plumbing up to code in a car. This sentence right here is saying stupid shit. You have no idea what you're talking about and pretending you do. Congratulations, you made yourself look stupid. Notice I didn't say Max is stupid. I said he looks stupid. Is that provocative language? Yes. So sue me. Anyway, there's phone numbers you can call to make an ass out of yourself for somebody who was pissing and shitting and sleeping in a public parking lot. If that is the particular hill you want to die on, you're more than welcome to it. It's your opinion, and it's just as valid as anybody else's. That said, it did look like a clean arrest from my point of view. Are there bad cops? Yes. Do some cops do bad things? Yes. Can good cops do bad things from time to time? Yes. Can bad cops do good things from time to time? Yes. There are bad situations out there that this is deflecting from. This is a person who is doing something wrong. He was not complying with the lawful orders of the police just to be stupid, and he earned himself a broken window and tack on charges that he otherwise would not have been facing. As far as him having to give the license to the police, as far as I can tell from the statutes in New Jersey, you have to exhibit it to the police. But every single defense lawyer in New Jersey on their website says, roll down your window. Maybe they know something I don't know. Maybe there's case law out there. I don't care to look for it. But if you choose not to hand your license to the police in New Jersey, maybe you'll end up with a broken window. Maybe you won't. I don't know. But if you want to do what the defense attorneys, not the prosecution, the defense attorneys are telling you to do, then roll down your window, hand them your license, comply if they tell you to get out, etc., and then let your defense attorney determine whether or not they violated the Fourth Amendment, and then let your defense attorney either recommend a good lawyer for a civil suit or bring it himself so that he can get paid to put the boots in the officer's ass if the officer actually did violate your rights. Thank you very much for watching. Beware of propaganda. Beware of anybody who tells you what happens prior to the evidence that they are presenting to you. And always be careful of people who have buckets of dirt in their cars. Have a good day.